Topic: Rights, under which we will first discuss the definition and meaning of rights. Harold Laski: rights are those conditions of social life without which no man can seek in general to be himself at his best. Hobhouse: genuine rights are conditions of social welfare, and the various rights owe their validity to the functions they perform in the harmonious development of society. The concepts of rights originated due to the protest against oppression by dominant groups in society. An individual is entitled to rights by virtue of his status as a human being. An individual is entitled to political, economic, civil, and social rights by virtue of being a citizen of a particular state. Rights are moral or legal claims of individuals or groups against society, state, or a group of individuals. The objective of rights is to create the atmosphere of freedom necessary for the development and realization of human personality. In the absence of freedom, no man can realize his best self. The emphasis is not just on granting rights with reasonable restrictions for the security of the state, public order, decency, etc., but an actual enjoyment of rights. Certain provisions have to be made for the realization of rights. First one, list of fundamental rights. If rights are to be enjoyed in a meaningful way, then an unambiguous declaration of rights of man in the Constitution is an important safeguard. The purpose is to prevent violation by executive and legislative authorities. Second, rule of law. Its essence is equality in the eye of law. No discrimination on the basis of caste, color, religion, language can go a long way in the protection of rights. Third, free press. A free, fair, and impartial press plays an important role in the protection of the rights of the people. Rights create public awareness and mold opinion to protect rights of the people. Fourth, decentralization of powers. If political power is concentrated in a single authority, the rights may not be protected. Local matters, when supervised by local governments, help in the protection of people's rights. Fifth, independent judiciary. If government encroaches on people's rights, the presence of an independent judiciary can protect the rights of the people, thus safeguarding it. Sixth, party system. The presence of a strong opposition can prevent the government from overstepping its authority and destroying the rights of the people. Nature of rights. First, not absolute. Absolute rights are neither possible nor desirable. Rights are subject to limitations imposed by the state in the interest of the security of the state, public order, etc. For example, freedom of speech and expression does not give the right to defame others. Second, not static. Rights change with time, that is, with social, political, economic, and cultural developments within the state. Therefore, rights are not static but dynamic. For example, right to property was originally given to Indian citizens but later deleted from the Constitution. Third, universal in nature, rights are enjoyed by all people irrespective of caste, religion, wealth, etc., thus making rights universal in nature. Fourth, legal, rights require the sanction of the state to make it legal. Such legal rights are incorporated in the Constitution which are justiciable. For example, freedom of religion is incorporated in the Constitution, but if it is violated, there is freedom to move the court. Fifth, inalienable, we are born with these rights which cannot be transferred to someone or taken away or denied, and therefore rights are inalienable. Sixth, rights associated with duties. Rights and duties are the two sides of the same coin. When a person enjoys rights, he should realize that others also enjoy similar rights and therefore should respect others' rights. Thus, enjoyment of rights involves obligations, that is, to perform one's duties. Seventh, social in nature. It is only in a society that individual can enjoy rights guaranteed by the state. Rights are meaningless to an individual if he is on an island. Thus, rights enhance the dignity and personality of an individual. Positive and negative rights. Isaac Berlin recognized two types of rights, negative and positive rights. He described the two liberties through a statement, I am slave to no man, which is a negative right, and I am my own master, which is a positive right. The former means freedom from another's individual's direct interference. The latter means freedom to choose one's own pursuits in life. Negative right means absence of external constraints, that is, no external interference by the state in the enjoyment of civil liberties. For example, freedom to move, freedom to assemble, freedom to eat, etc. Positive right means to develop one's personality with the opportunities given. Therefore, it is not enough to provide opportunities. What is essential is to create the right conditions for the development of one's personality. For example, access to public facilities and resources of the state is an opportunity, but special provision for women, for example, reservation of seats for women in public transport, is creating the right conditions for the development of one's personality. The evolution and historical development of rights. The evolution of human rights can be traced back to centuries and various events. First, the Magna Carta 1215, also known as the Great Charter. The charter was drafted to make peace between unpopular King John and group of barons. The charter guaranteed civil and legal rights to citizens, protection of church rights, protection for the barons from illegal imprisonment, and levy of taxes with the approval of the Council of 25 barons. This charter thus prevented the king from exploiting his power. Second, the English Bill of Rights 1689 was enacted by the British Parliament after the Glorious Revolution. The bill laid down the powers of the monarch, the rights of Parliament, the rights of citizens, and codified the customary laws. Third, the American Declaration of Independence 1776. The 13 states of America revolted against England and declared their independence on 4th July 1776. This declaration established principles of democracy, personal freedom, and protection of rights. This declaration gave the right to revolt against a government. Fourth, the French Declaration of Rights of Man and of the Citizen 1789. The declaration adopted by the French National Assembly in 1789 emphasized that all men are born and remain free and equal rights, thus establishing social equality among citizens. The divine rights of king, followed by French monarchy, was replaced by popular sovereignty. The declaration served as the basis for many constitutions framed in different countries of the world. Fifth, the UN Charter 1945. After the Second World War, nations was established for maintaining peace and security. The UN Charter made a reference to human rights for the first time and established provisions for the promotion and protection of human rights. Sixth, the Universal Declaration of Human Rights, 1948. In 1946, United Nations established the Commission on Human Rights, the policy-making body for human rights within the UN system. The Universal Declaration of Human Rights was adopted by the General Assembly of the UNO on 10th December 1948. The Commission defined basic rights and freedoms such as civil, political, economic, and cultural, which should be available to all persons irrespective of their religion, race, caste, etc. The declaration is not binding on member nations, but an ideal which every nation needs to adopt.